Members, we have attained the quorum, and it's about time to make a start. Subcommittee on Business Registration Ordinance Amendment Schedule 2, Order 2013 is now called to order. Item 1, election of chairman. Mr. Leung Chi-Chung, I nominate your good self, Mr. Ting-kwong. Mr. Kohim, I second. Yes, I accept the nomination. Any further nomination? No other nomination. Thank you very much for your support then. Shall we invite the administration in, please? Do we need a vice chairman? No? No further views? So we can do without a vice chairman. Shall we invite the administration in, please? With us for today are Mr. Ernest Yip, Assistant Commissioner for Labour Department, Mr. Bonnie Wong, Senior Labour Officer, and Ms. Cindy Chuck, Government Counsel, DOJ. I will get started when the guests are all seated. Declaration of interest. I own some companies. I'd just like to make the declaration. Right? So you have to pay the business registration tax. Yes, me too. I have a limited company. Mr. Poon, I don't own any company, but I'm a member of the PWIF board. Mr. Yu, I'm not a businessman, but my company has some business interests there. All right, let me make the declaration myself. I've got some companies myself for which I have to pay the business registration tax. All right, shall we invite the administration to brief us on the Business Registration Ordinance Amendment of Schedule 2, Order 2013. Chairman, thank you. The Business Registration Ordinance order was gazetted on the 24th of May, and it was tabled in the Council on the 29th of May. We have starting from July the 19th, the rates of levy will be reduced from $450 to $250. The fund board has been having regard to the financial situation and economic situation to review the situation. In 1985, the fund was set up. The rate of levy was $100 per year, and there were 3 adjustments subsequently. In 1991, from $100 up to $250. And during after the Asian financial crisis in 2002, the financial situation of the fund wasn't good enough. It went up from $250 to $650. It was in March 2008 that we reduced it from $650 to $450. This is the 4th time we talk about an adjustment, downward adjustment. The expenditure has been reducing. The financial situation has been improving. The PWIF board had regard to various factors and decided to reduce the levy to $250 back to the May 2002 level. It has been endorsed by the LAB. We also consulted the panel. At this rate, the fund should have sufficient reserve to meet the cash flow situation. Should there be any reversal in the economic situation, should there be any upsurge in insolvencies, there would be sufficient fund to meet the needs. We have taken into account the views of the employer and the employee. We make sure that the fund will function properly. I urge members to support the proposal. Now, we have got an electrical brief for members in which we do have some salient points, and I hope that members might wish to refer to it. In this electrical brief, there are 3 annexes. Annex 1 refers to the order. It will go into effect on 19th of July this year. It mentions that on the 19th of July or thereafter, if someone elects to pay for 3 years, no one can elect to pay the BR fee for 3 years. Now, for 3 years, it is $750. If there is no such election, then the business registration tax would be $250. I'd like to mention in passing that in the paper there is there are tables A and B regarding the claims payment over the past 6 years. In table A, 0708 to 12 to 13, over the past 6 years, all the claims payment is listed there. $79 billion. And 2012 to 13, $60.6 billion. So there has been some fluctuation over the years, and the expenditure, the outlay, is affected by the financial situation. 0809 a rise by 60%. As the economy got better, the claims decreased. In Table B, we have the financial position of the fund over the past 6 years. We have the income, the expenditure, the surplus, and the accumulated surplus. In 0708, accumulated surplus stood at $1.22 billion. 12 to 13, $3.28 billion. In 08 March, we did reduce the fee from $650 to $450. In 0809, the income was smaller compared with the previous year, $559 million to $471 million. And we subsequently had an increase in income because of the persistent improvement in our economy in Hong Kong. I'd just like to draw members' attention to paragraph 6. Given this kind of claims and expenditure and the financial position of the fund board did review the reduction in the levy level. It had regard to a number of factors. Hong Kong is a highly externally oriented economy. Hong Kong's economic prospect is susceptible to external factors and volatility. Take 2002, for instance. The claims stood at 23,000, and in 2012 it stood at 2,000. The expenditure was $500 million in 2002 versus $60 million last year. All the details are sent out in the appendix. Or it past 11 years, all the details are sent out in Appendix 2 or Annex 2. It shows that over the past 11 years, the fund expenditure ranged from $50 million to $4 million, $600 million, $400 million, and now it is $60 million. Now, the fund board has been very prudent in its management to make sure that there will be sufficient cash flow and reserves to cater for the reversal of the economic situation and upsurge in claims. In 0708, during the financial tsunami, it has registered a deficit. It was very serious in 2002, and we have seen improvements subsequently. The third scenario was that last year in 2002, June the 29th, we had expanded the scope of the fund to cover pay for untaken annual leave and untaken statutory holidays. This brought about some implications on the fund. Having had regard to all this, we came to the conclusion that the levy rate would be reduced from the current level of $450 to $250 per annum. Annex 3, now over the past 6 years, we have 2 additional items added. If we maintain the level of $450, the income would be that much greater, and the reserves would be $3.7 billion. But if we reduce it to $250, we may still have some reserves, or a little bit lower, and it would be $3.4 billion. And in 13-14, the inland revenue will have 1.1 billion business registrations, and we worked out figures on that basis. The paper also mentioned public consultation. With regard to this adjustment, the LAB came to a consensus to reduce it from 450 to 250. And after the endorsement of the LAB, we took the proposal to the manpower panel of the Council for discussion. Members in general supported or did not raise an objection to the proposal, although some members talked about the sound financial position, and they like to have an expansion of the scope. And we have referred this to the Fund Board for consideration. At its meeting on May the 7th, the Fund Board reviewed the situation and agreed that for untaken annual leave and untaken statutory holidays, there will be a review to be conducted, and during that review exercise, it would examine all the issues raised by members, like severance pay and all the wages and so on, proposed by elected members. We have mounted some publicity for this amendment. The Labour Department, Companies Registry, and Inland Revenue will be posting all this information on the web, and the Labour Department has a hotline, 27177177. There will be inquiries that will be answered. And during the Gazette, we did issue a press release, and we're going to have designated officers answering all the inquiries. Thank you so much. All right, and I now throw the floor open for questions. Mr. Lee Chuk-yan. Chairman, thank you. The manpower panel did have some discussion. Members were unhappy about this revision, this without examining the fund in its entirety. Now, the fund is awash with reserve $3.3 billion. This is historical high. About 5-6 years ago, it was $1.3 billion. Now it is as much as $3.3 billion. I have nothing to say against the downward adjustment, but if you do not expand the scope, I am really furious. I'm furious that you're not doing anything about the scope. Nobody will say anything about the reduction in the fee. Now you're going to have you're going to lose $108 million. Now, there is an offsetting arrangement against the SP, and it doesn't pay a lot in this regard. Now, we have seen less insolvencies these days. Now, the trend is that the expenditures is going to be less and less. Why don't you expand the scope of protection for the workers? At the manpower panel, we did make a similar point. I'd like to reiterate this point. First of all, about the severance payment, the offsetting mechanism in this regard. Will Mr. Ip tell us why, after the offsetting between the MPF and the severance pay, why is it that you don't pay the full amount of the balance. Say, for instance, maybe Mr. Ip can confirm that. Now, let's say severance pay is $100,000. First of all, they will offset $50,000, and then another half of the $50,000. Now, for these $100,000, they have offset $75,000. Well, out of these $100,000, the PWIF would pay $75,000. Now, if it is $80,000, the $20,000 will be there will be nothing much left. Now, let's say severance pay $100,000, offsetting $80,000. Now, it would be $20,000 left. So you're not going to collect the whole amount of $20,000.
Second point, which I already mentioned at previous discussions, they are about statutory holidays and annual leaves not taken. 4 months for statutory holidays and annual leaves. Just a short period, they are not covered under the PWIF. The wages in arrears and all the untaken leaves are not reviewed. Mr. Ip said, there will be a comprehensive review. When is that? If we agree to lower the BR fees, but you do not have any undertaking about when you are going to review the points I've made, or what will happen? Mr. Ip, 2 questions for you from Mr. Lee. First of all, to expand the coverage under the PWIF, and the second question, when will the review take place? Thank you, Mr. Lee. The PWIF was set up in 1985, and the contribution, or rather the payout, was just $8,000. However, up to now, the total amount, the maximum amount to be claimed by the employees can amount to $289,000. So we have been doing some reviews. As for the calculation of severance payment, the PWIF is not there to pay outstanding amount owed by employers to employees. If the company closes down, the PWIF is there to make protection. However, there is a ceiling to all these protections. For $100,000 of severance payment, the employee can get $75,000 according to the principle we have. That is a maximum of $50,000 plus 50% of wages not paid. Second point, we already undertook that there will be a review in a year's time concerning annual leaves and statutory holidays not taken. On the February 19th this year, at the Manpower panel, Mr. Lee and other members asked about reviews concerning wages in arrears and also leaves not paid. All these views have been passed on to the fund board. So in our review, we will cover the mechanism concerning severance payment and the leaves unpaid, leaves untaken. Is there a timetable? For the $100,000 of severance payment, after the offsetting effect of MPF, how much will be paid out of the fund? After the offsetting effect, the worker can only get $20,000. So don't tell us that the fund is not there to cover everything owed by employer to employees. It seems that you say that after the offsetting effect, the worker cannot get up to $75,000 if the severance payment is $100,000. The ordinance came into effect on the 29th June 2012. So we can only conduct the review after we consolidate the information from then up to the period of July this year. So there will be a review this year, yes, in the second half of this year. Don't be so vague. Can you undertake the review will be completed at the second half of this year? You have 6 months. That's more than enough. Can you undertake the review can be completed by then? That depends on the progress. We propose to review the leaves not paid. On the 29th of June this year, Mr. Lee and other members asked to review severance payment coverage. We undertake to do that, but we need time to get the information. Mr. Lee also asked to review the wages in arrears. So we have to look at all these matters. We'll start the review at the second half of this year. I don't accept that. Mr. Lee asked the department to give a firm undertaking. Don't just say you will start the review. Give undertaking on completing the review. You bring down the fee at such a fast pace, but for expanded coverage, you are so slow. Can you complete the review within this year? We'll try our best, but the board has to discuss the matter. There are bound to be different views. I can't undertake when the review will be completed. What I can say is that we will go as fast as possible. Mr. Tam Yu Chong. Speakers of mic. Not a lot of members were waiting, but now we have 5 waiting in the line. So 5 minutes each. Early on, just Mr. Lee was in the line, but now we have several. So I'm going to set the time limit 5 minutes each. Chairman, according to the Labour Department, the fund is not there to give protection to employees on behalf of the employers. So there is no full coverage. The Labour Department is not taking up responsibility here because under the labour laws, the employees cannot get what they deserve. The fund cannot give them full coverage, so who loses? It's the employees. So is that the attitude of the Labour Department? That's my first question. Secondly, we have so much reserve in the fund, but the LD does not propose to expand the coverage. Even when we ask you to do so, if we do not raise it, then you would not even look at it. You simply pass the buck shirk your responsibility. I am very dissatisfied. Mr. Lee asked you to start the review, but you only say that you will have a review in the second half of this year. What about the direction? You should have a direction. When can employees get full coverage, full protection? These people are not greedy. They're not asking for something extra. It's what they deserve, what they should get. How come the workers cannot get what they are entitled to? So my question for the LD is, do you have a goal? Do you have an objective to ensure workers get full coverage under labor laws? Resort to the fund or other means to ensure they get full coverage. They should not lose anything less than what they entitle. Mr. Ip, thank you, Mr. Leung. In enforcement, we have done a lot for benefits and wages in arrears. The employees can report the matter to the Labor Department. For closure of companies, the fund already covers a lot of protection to employees. For example, wages in arrears, severance payment, wages in lieu of notice, annual leaves and statutory holidays not taken. All these are covered. Well, if everything is covered, then how come we're having this discussion? The items may be covered, but not the full amount. So he's not telling the whole truth. So Mr. Leung is accusing you of not telling the whole truth. Severance payment is not fully covered, or unreasonably sacking someone, that's not covered. As I understand, Mr. Ip says the items are covered, and Mr. Leung says the items are covered, but the workers do not get the full amount. Mr. Leung agrees that the items are covered, but the workers do not get full protection. That's the point, right? Mr. Ip, the items covered, for the items covered, there has been effort to raise the ceiling of amount compensated to employees. For most of the applications we receive, there are about wages in arrears of 1 to 2 months. But with our inspections, the situation has improved. And so for the cases involving wages in arrears, most of them are about wages in arrears of 1 to 2 months. Mr. Ip, what about the ultimate goal? Are you moving towards full protection for workers? Apart from stepping up inspection. Let me put it this way. Our policy is not to give full payment of what the employers owe the employees. This is the principle of the fund. Ms. Sit Ho. Chairman, I share the views of Mr. Lee Cheuk-yen. It's fine to you to reduce the BR fees since you have so much reserve. But you haven't expanded the coverage. This is what's frustrating. In the previous term, there were new measures about legal aid. Members from different political spectrum thought that if the employees' cases were accepted by the Labour Tribunal, and the employers resort to other means so that the employees cannot get the full protection, the employees still have to pay part of the legal fee. So in the end, the employees may not get anything at all after taking into account the legal fee they have to pay. So in last term, we already asked, how come you can't give legal aid to the employees to take their employers to court from the fund? The employers can hire expensive lawyers to take the case to court, and in the end, the employees will not get anything in such a case. So can you discuss the coverage of legal aid with LAB? That's my first point. Secondly, when the employer goes bankrupt, then the employees will have to take the case to court and has to apply for legal aid as a result. So can the PWIF provide legal support too? The employees have to wait for the court's ruling before they can get any money. So shouldn't the PWIF give the employees legal aid? Can you take my views to the LAB for your discussion and tell us when the discussion will take place?
Mr. Yip, thanks very much, Madam Ho. Under the PWIF, it is intended to make sure that during insolvency, the SP, the payment renewal notice, will be covered. Now, we do have to have an insolvency or bankruptcy petition before the fund would disperse the money. We do have a division of labor between us and the legal aid department. If there is a petition for bankruptcy or insolvency, then there will be a petition at the High Court. If you ask the PWIF to set aside funding for people to seek legal aid, there may be difficulties, because they have to go to the legal aid department for this. Ms. Ho, Chairman, well, we did discuss the expansion of the supplementary labor scheme, supplementary legal aid scheme, and they said they run out of funding. Now here, you're awash with surplus. You are flooded with so much money that you have to reduce the levy. Why can't you communicate between the two departments, Mr. Yip? Well, I can convey the views to the legal aid department for consideration. Ms. Ho, what about the Bureau? Well, I don't think you can twist Mr. Yip's arms. He doesn't have the authority to answer this question. He's undertaken to relay the proposal. Now, this is not within his remit. Well, I think he has already said that he would do so. Or will the Bureau? Now, this is for negative vetting. We're going to speak on this during the council meeting. Will there be a paper made available to us before the council meeting? Mr. Yip, can the paper be made available? Well, I can convey the views to the relevant bureau for their consideration. Mr. Andrew Leung, Chairman of the BPA, supports the Business Ordinance Amendment of Schedule 2, Order 2013. I think Mr. Ip has got a point there. The PWIF is dispersing ex gratia payment during insolvency situation. This is an ex gratia payment, but the fund is not there to pay on behalf of the employers. Now, we've said that the whole idea is for the good employers to subsidize the bad employers. I sat on the PWIF before, but previously it was not until the PWIF was on the brink of bankruptcy that we tightened the rules, and Matthew Zhang investigated the whole issue. And I think good employers, we're talking a lot about the SMEs. It is only right that there should be sufficient funding. I agree. I would agree that the employer and the employee should be discussing this in a mutually accommodating manner. But I don't think we should expand the scope in a limitless way. The fund cannot be used for other purposes unless we're going to change the law. So I think we have to tread carefully in this regard. The PWIF is there to help the unfortunate workers. It takes collaboration between the two parties. Now, if the workers have wages in arrears, they have to notify the Labour Department. Now, if there are statutory leave period for 3 years that has not been paid for, you cannot say that this should be covered by the fund. I think the administration has to hold fast to the principle. Just because you have a lot of money in the fund doesn't mean that you should open the floodgate to unlimited demands, because that would not stand the workers in good stead at the end of the day. We support this proposal. Right, this is a comment. Mr. Pun Xiuping, next please. Chairman, a moment ago I made the declaration that I am a member of the PWIF. Earlier, members expressed concerns about the possible expansion of the scope of the fund. On May the 7th, the panel had some discussion, and we did talk about the possible expansion of the fund. Some said that the PWIF is flooded with money, with 3.3 or $3 billion odd dollars. The fund is there to offer ex gratia payment in insolvency situations. I think, to be fair, the employer and the employee representatives on the board agree that going forward we should review the scope of the protection. That the Labour Department, that a year after the leave coverage has been introduced, there will be a review. Now, there are suggestions that the SP and so on should be incorporated in the review. Now, there is a judicial review involved. The Labour Department got the sum wrong regarding the offsetting of severance pay, and that has to do with the review period. And I'd like to find out more from the Labour Department if the judicial review shows rules against the administration, then some employees may be claiming the amount owing. I hope that the two will go in tandem. We're not sure how long the legal proceedings are going to be for. The measures put in place on 29th of June will be subject to review in a year's time. I think there should be more information for discussion. You may bring the electrical up to date at a suitable time. Have you factored in the possible discrepancy in amount as a result of the legal proceedings? Mr. Yip, Chairman. Well, with regard to the review on the statutory holiday, untaken statutory holiday and the annual leave, we will be keeping this under review in a year. We will also be looking at the severance pay and the payment in lieu of notice. Mr. Yip mentioned the court case regarding the calculation of the severance pay. We're not sure how the case is going to be turning out. This might have implications on the question of severance pay. Now we will then consider how best we will deal with that. Are we going to take away the SP, or are we going to wait for the judicial review? We've got no idea how long this judicial review is going to be taking. Chairman, I must make the declaration that I'm a director of a number of companies, and this reduction will benefit these companies. Mr. Ip-kwong, Chairman, I must make a declaration. I am a non-executive director of a listed company myself. With regard to this piece of legislation, the DAB is in support. Now we are of the view that given the sufficient funding available, this proposed reduction is a step in the right direction, because this will lessen the burden of the employers. Some members raised or given the sufficient reserves in the funding, the possibility of offering better protection for the workers. Now that we agree, because if they cannot get back the wages that they deserve, then it is wholly unjust. And I don't think this is acceptable to us at all. We have to safeguard the interests of the working population. Now, given the PWIF, the good employers are basically supporting the bad employers. Now, if the unscrupulous employers are taking advantage of the system and exploit the situation, then it's not a really good situation. We have to strike a happy balance there. I think the administration ought to do more. Like, for instance, and there ought to be more publicity to make the workers aware of the fact that their claims should not be dragging on for too long. And also, as far as the unscrupulous employers are concerned, something ought to be done to tackle them. There ought to be action taken at different levels to achieve the desired effect. I think the employers will have to be held responsible in this regard. Now, at the present moment, as far as the unscrupulous employers, they choose to go bankrupt to evade the legal liabilities, so that they don't have to be held responsible for the compensation. Now, what sort of supervision or monitoring is being undertaken by the administration? Do you take any proactive measures to supervise the situation?
Ms. Yip, any proactive approach to deal with these people? Concerning protection of employees, provided by the fund, we have stepped up publicity so that all employers know that they should pay their employees on time, and that the employees, on the other hand, should report unscrupulous employers. In some cases, employers and employees, they conspire to cheat the board, to cheat the fund. And at the blip of the fund in 2002, when we had to borrow a large sum from the government, we asked the LD, the police, and other relevant departments to set up a working group to target on companies which transfer their assets before closing down. Apart from the abuse of the fund, apart from dealing with them, we put in more resources and money to protect the rights of the employees, and we also penalize the employers who broke the law. You talk about something you were already doing in 2002, any new measures for employers who do not pay wages in time. We ask the employees to suffer to report the cases to us. So we have hotlines for them. Does it mean that the existing measures are already effective? Yes. Next, Mr. Yu Siwing. Thank you, Chairman. The reduction in BL fee is not a lot. I want to point out that SMEs are struggling in the operation, so even a small reduction in BL fees is very encouraging to them. So I support the reduction. Last year, there were 2,900 odd cases of applications. How many of them were rejected, and for what reasons were they rejected? Just now, a member mentioned that some employees had to take the case to court to fight for their rights, their pay in arrears. Were there a lot of such cases last year? Any statistics in this regard? If so, how are these cases dealt with? For the legal fees, are the employees have to pay for that? You have a reserve of over $3 billion. Has the administration set down a line before it considers raising the fee? For the 2,900 odd applications, how many of the applications were rejected? I don't have the exact number. During our processing of applications, we see whether the applications fulfill the requirements under the PWIF. If the case is over 6 months old, the applications can not be accepted. And in some cases, some items are not protected under the fund, so in that case the application is rejected. And if there is no employer-employee relationship established, then the application will also be turned down. So in other words, for normally the applications are granted, and the cases you cited are the ones that are not really normal. Right. The second question, when will we review adjusting the fee? We review our financial position and expenditure from time to time. And the reduction of fee proposed here is the result of one of the regular reviews. In the second half of this year, we also review whether there is room for improvement for severance payment, untaken annual leaves and statutory leaves, and wages in lieu of notice. We hope we can make some improvement. And the review will also cover financial position. Mr. Yu asked if you will raise the BR fees when the reserves falls under a certain level, and whether you will bring down the fees when the reserve is above a certain level. In April 2008, we set up a mechanism. We set down a floor and a ceiling for the reserves. Respect 800 million and $1.2 billion are the floor and the ceiling. If the reserve is under the floor for 4 consecutive quarters, we will adjust it, and if the reserve is above the ceiling for 4 consecutive quarters, we'll also go for adjustment. And the last adjustment was in 2010. We reviewed, the latest review was in 2010, and the reduction of fees we propose now is the result of the last review. Mr. Yu, follow up from you. Court case, or rather the legal fees. Please go ahead with the question. I wanted to know if any employees who took the case to court last year because of closure of the companies, and whether these people had to pay out of their own pocket for the legal fees. Have you got any statistics for that? Were there any employees who took the case to court and then had to pay for legal fees? When you mentioned court cases between employers and employees, I'm not quite sure what you're talking about, because in the labor tribunal, no lawyers are engaged, so the claimants and the relevant parties do not have to pay the legal fees. The PWIF covers 2 scenarios. First, for bankruptcy petition, the legal aid department will process applications for legal fees, and if the application is granted, the PWIF will give a subsidy to the employees. Second scenario, for a case with fewer than 20 claimants and there is evidence showing that the employers will be bankrupt, where it's not cost effective to make the bankruptcy petition, the payment in arrears will be paid to the employees directly. Do you have a lot of such cases? If you don't have the information in hand, please give us the information later. In 2012, 29% of the applications we received did not involve any legal proceedings. In 2012, 791 cases were about that, and that amounts to 35%. Next, Mr. Tommy Chang. Is it my turn? Mr. Tommy Chang, you raised your hands earlier on. Sorry, I did not hear you right. I thought you were calling Mr. Chang Kwok-chu. I did not quite follow the discussion, and Mr. Lee Cheuk-yen has stepped outside. I don't want to point finger at him behind his back. Today, we understand that there is a lot of reserves in the PWIF, and so the administration proposes to bring down the BR fees, but it seems the discussion has digressed. It seems that members are asking the Labour Department to do a lot. If the administration is capable, then they can do things at a faster pace. If not, they will be slower, of course. It seems members are talking about all sorts of things. If that's the case, then I'm going to adopt this approach too. I am quite upset because some employers who were asked to give payment to workers from the PWIF, the employers cannot start any companies even after they were sent to jail and they have served the terms. It's not fair to the employers. So my question for the administration is this. Can you also penalize the employees too if they cheat the fund? Say, for example, the employers and employees conspire to cheat the fund. Will you penalize the employees too? Say, for example, do not allow their applications for the next 5 years. Can you do that just to be fair? Because you penalize the employers even after they have served their terms in prison. They are not allowed to set up their own companies even after that. So what about the treatment of employees, Mr. Ip? I agree with Mr. Chang. We are here asking members to agree to bring down the fee to $250. We should not digress. I agree with you, but Chairman, you allowed Lee Cheuk-yen to ask so many questions about digressing from the discussion. Ms. Ip. Now, for employers or directors who brush shoulder with the PWIF, they are not allowed to set up their companies for a certain period of time to prevent them from cheating other workers. So there is this mechanism. Apart from criminal prosecution, there is also civil proceedings to stop these people from becoming a director for a certain period of time. You should be fair. You have this mechanism for the employers. What about the employees who cheat the fund? Say, for example, bar the employees from applying for the fund in the next 5 years, just to prevent them from cheating the fund from time to time, again and again. I'm talking about someone, a worker who has been convicted for fraudulent acts. I don't think it's unfair if you bar this worker from applying with the PWIF. You should be strict to both employers and employees to be fair. Ms. Ip, you may like to take the views back.
Well, if someone has cheated the PWIF, Shall we bar him for 5 years from making similar claims with the PWIF? Mr. Zhang Guokchu, sorry, I almost jumped the queue, beg your pardon. Chairman, I've been listening to the arguments. I'd like to seek some figures. I understand that the minimum under the PWIF is $50,000. Anything beyond that, it would be halved over the past 5 years. How many cases exceeded $50,000? The subsequent amount would be halved. How many cases like this? Also, now after the second amount, the half, the 50%, there will be no more. Now, Mr. Li Cheng-yen quoted some examples. I don't think I've heard the satisfactory reply. In theory, that the PWIF started in the 1980s, it's been around for 30 years. The MPF has been around for about a decade, or 13 years to be precise. So the $50,000 or half of the $50,000, that when that was put in place, that didn't take into account the MPF, but the MPF has this offsetting arrangement against the long service payment and SP. So if you pursue that, there will be an offsetting arrangement. Now my question then is, the offsetting arrangement, does it include the $50,000 and half of the $50,000, or how does it work? Which one comes first, an offsetting arrangement? Mr. Yip. Mr. Li Cheng-yen's example, how does it work in reality? Let me quote an example. Let's say there is insolvency, there is a substance payment of $100,000, and it has the MPF and the accrued benefits for the employers, let's say stands at $40,000. Now, under these circumstances, how much will the workers be entitled to under the PWIF? At the moment, the $50,000 and half of the remainder for $100,000, first $50,000 plus the remainder half, that is $50,000 and plus $25,000. So we can draw at most $75,000 from the fund, assuming that from the employer's contribution, there is an accrued benefit of $40,000. Now, this there will be $40,000 accrued benefits to be subtracted from the $75,000. So the worker will be entitled to $35,000. That's as much as he would get under the fund. From the employers, he would be getting $40,000, a total of $75,000. $35,000 from the PWIF. Now this calculation formula, before the introduction of the MPF, we had the ORSO scheme, the occupational retirement scheme. There was the same formula. MPF, the ORSO scheme has been around for some considerable time. The MPF came about in 2000. So this formula was in place, and offsetting arrangement was in place before the year 2000. Mr. Zhang, well, under the ORSO scheme, there wasn't an offsetting arrangement. I think you have to get this clear. It's only under the MPF that you have offsetting. Well, under the PWIF ordinance, we apply the same formula because under the ORSO scheme, there is an offsetting arrangement under the employment ordinance, and that's the same offsetting idea. Mr. Zhang, well, if this is the case, if a worker is under the MPF, he will stand to lose considerably. Is that the case? Well, he'll be losing considerably. He'll be losing $40,000 at least under this arrangement. Mr. Yip, well, the employer has contributed $40,000. That's what the employer owes the worker. The employer has to pay the severance pay, and that will be offset from the MPF. And the fund is not meant to underwrite all the amount in arrears. Now, you are suggesting that the fund should underwrite everything, but when the fund was set up in the first place, it was not meant to underwrite everything that is owed to the workers. Well, it's not meant to underwrite everything owed by the employers. That wasn't the policy of the PWIF at the time. That's why we have the $50,000 plus 50% of the remainder. Mr. Zhang, well, I understand that. I'm asking whether this would be incorporated in the review as well. Well, indeed, there would be a review. I've listened to members' views, and we are responding proactively. Well, if the data can be made available today, fine. If not, after the meeting. Well, can you repeat the question? Well, the two figures, what are the two figures you are seeking? Over the past 5 years, each year how many cases were there, how many claims were made, and how many claims in which they didn't get the full amount. Right, the two sets of figures for the past 5 years. Under the PWIF ordinance, if they cannot claim the full amount, how many cases are there and how much are we talking about? Right, Mr. Tony Jay, Chairman. Well, today we are basically discussing this reduction in BR levy. I support this. We have seen ups and downs. We have seen increases and reductions. When the funding is good, it's only right that we reduce the levy. Some members suggested that given the colossal reserves, we should expand the scope of protection, or we should increase the amount of protection. That can be considered at a later stage. Now, we talked about the MPF offsetting. Well, I think that we have to consider this. Basically, given the amount of funding available, it's only right that the levy be reduced. In terms of the scope and the amount, well, I don't think we should give the impression that we are not doing anything at all. Now, there are some employers who are unscrupulous, and so for these unscrupulous employers, and for those who are banding together to swindle the PWIF, and something ought to be done to tackle this. We should not give away the impression that nothing is being done there, and the fund is underwriting everything, because otherwise that would be unfair to those hard-working workers. So I think a penalty in this regard should be considered. We should mount more publicity to advise the workers not to report the cases too late. Well, this is by way of a comment. I don't think I need a reply. Okay, then round number 2, we have 2 members, 5 minutes each. Mr. Li Cheng-yan. Chairman, thank you. Well, I am concerned about the the point raised by Mr. Pun Xiuping, the judicial review. Whenever there is some judicial review, the government would stop everything until the JR has been complete, and this doesn't sound right logically. JR is about something in the past. Improvement is about going forward. I hope that the administration will tell us that you have given the undertaking that you would consider incorporating severance payment in the review. It is considered fair and fair. Now, with the offsetting arrangement, instead of getting $100,000, one would have only $75,000. In fact, he should be getting $25,000 as well, instead of being deducted. If after the offsetting you have $20,000, that should be paid as well. If it is more than $50,000, we can cut it by half, for instance. Well, I do think there should be offsetting arrangement in the first place. I think after offsetting, the PWIF should pick up the tabs. Second, as regards the timetable for the review, now you said that you would proceed as soon as possible. That doesn't go far enough. During the council meeting, we're going to be speaking on this subject. I hope that you will give a timetable. If you fail to do so today, maybe during the logical sitting, you should give us a timetable about the review as well. And we will be in a position to know about the government's position. And we don't have to put it to the vote unless I choose to repeal the entire order. But I might mull over this point. If we are serious about the review, we don't have any objection to the reduction to $250, even to zero, because that will last us for about 30 years. So I don't think you should be so stingy. You have to come with a reply. Right, Mr. Ip? Right, Mr. Ip pursued the question about the judicial review and also the timetable, not judicial review fee. During the judicial review, you should effect the improvement. You should not wait until after the JR. The JR might last for 3 years, and you're sitting on these, so I think you're holding everything to as hostage. Right, Mr. Ip? Can you do something during the JR period, Mr. Ip? Well, I can give the undertaking that we will carry on with the review during the JR proceeding, including the severance payment. We heard members' concerns. We'd like to do something to effect improvements, but whatever improvement we effect, we have to do so through legislation. The JR result would certainly have implications on severance payment unless the court rules in favor of the administration. If the court rules against the administration, we have to look at it all over again. There may be some difficulties there, but I can give you the undertaking that the review will not stop, notwithstanding the judicial review. Timetable. Well, even after the review, we have to refer the matter to the fund board for discussion, and then the LAB. There may be a bit of a time lag. The Labour Department has been very earnest. We will refer the results of the review to the fund board, and then at the LAB. That's always been our practice. We'll get on with the review as to how soon this will be completed, or whether there will be any consensus, or how this is going to be panning out, and how much should the while on be increased by, and what about the severance payment. And I think we need to build some consensus before we can take the matter to the manpower panel. All I can say is that we'll go through the LAB and the manpower panel as soon as we have the consensus. There will not be any delay. No, there will not be any stalling at all. We'll be addressing these issues proactively. This is the role that we have been playing all along.
You have a timetable for us. You can't press him further. He already undertakes there will not be delay. I think this is the best answer you can offer. Don't think he means no. When he says no delay, he means no delay. So you accuse him of not respecting the panel, the subcommittee. I don't think as a LegCo member we should adopt that mindset. Next, Mr. Leung Yiu-chung. Now the process, first of all, there will be reviews by the Labour Department, LAB, and the Fund Board, and then the matter will come back to LegCo. There may be a consultation exercise too. That will take us a year or more than a year before any review is implemented. It's too long. We may not be able to press the department further, but with the long period ahead, can we ask them to expedite the review? Concerning the BR fees, there is a mechanism for adjustment, say $800 million and 1.2 billion as the floor and the ceiling. But there is no mechanism for reviewing coverage for employees. This is not fair to the employees. So can you set up a mechanism to see how you can expand the scope of the fund? You have a mechanism for adjustment of fees, but no mechanism for review of the coverage. If we did not raise the review issue with you, you wouldn't even think about conducting a review. Now you respond to our request. This is good. So can you also have a mechanism to review the scope of the fund? So to set up a mechanism to review scope of the PWIF. The department keeps saying that the fund was not set up to give full protection to the employees. Let me say, how can you ensure that workers will get what they are entitled to in the end after they have worked? Mr. Leung asked about the mechanism for adjusting the fees and adjusting the scope. With 3 adjustments of the fees since the fund was set up in 1985, and this is the 4th time we adjust the fee. Since 1985, there have been 8, or rather 9, reviews of the scope. So we have done a lot in terms of reviewing the scope of the fund, even though there is no mechanism for that. It's meaningless. You only make a small step after we push you. Without a mechanism, we have to push you along the way. So when we have another opportunity to press you further, you said you will step up publicity and penalty. And some members and you expressed your worries that the fund will attract fraudulent acts. But you cannot mix the two together. That is, mix the setting up of the fund and the fraud cases together. So ultimately, you have to ensure the workers can get what they are entitled to. Mr. Leung, the PWIF looks at the number of claims and the amount of claims. We also look at the difference between the two items. All along, 90% of the applications are granted, and from that, we think the fund is working effectively. For the $22,000 of wages in lieu of notice, the workers can get the full payment of that. These are indicators that show us whether the fund is working effectively. I don't want to dwell on this. Can you give us a report to show what happened in the past 2 years? Shouldn't the manpower panel take care of this? Because you're suggesting a long report. Mr. Leung, you're also on the manpower panel, right? Can you ask the chairman of that panel to take this up? The chairman of the panel is here. Is here with us. This is a subcommittee, and what you're asking shouldn't fall into the ambit of this subcommittee. I do not hold much power. Chairman, I think the matter is related to this subcommittee. Of course, they're related, but I think it has more to do with the manpower panel. I agree with Mr. Lee Cheuk-yan. If the workers get full protection, I'm fine with if they do not charge BR fees. Mr. Chang asked for data in the past 5 years. I'm simply asking for the amount workers get under different items. In fact, I have the figure. In 2011-12, wages in arrears, 75% was granted. That is 75% of the wages in arrears were granted to workers, and the wages in lieu of notice, 99% was granted to the workers. That's all for the Q&A. Scrutiny, deadline for scrutiny is 26th of June. That is 13 days from today. And the deadline for giving notice of amendment, 19th of June. If we can't complete our discussion, we have to extend it up to the 21st of June. Deadline for giving the expiry for scrutiny period to be extended by resolution will be 17th of July, and deadline for giving notice of amendment, if scrutiny is extended, 10th of July. Let's go to clause-by-clause scrutiny now. There's a marked-up copy. Paper number CB-2, 1329, 1213, bracket 02. Let's go into clause by clause by looking at the marked up copy. Ms. Wong. Thank you, Chair. May I refer members to the marked up copy of the BRO? We propose to amend Schedule 2, the table in Schedule 2. May I refer members to page 3, Clause 4. There is the word table. The payment of BR fee is in number 3. Red. The amendment of 2010. The DOJ makes a technical amendment to 3A. The amended 3A reads on or after 21st February 2011 and before 19th July 2013, which is the commencement date of the ordinance, of the amendment ordinance. The existing levy will be in place until the commencement date. So under 3A, you find the commencement date, that is the 19th of July this year. And the new levy is also included. That is $250 where no election is made under Section 65C. All right, that's clause by clause. Any further views? So what are your views? The administration will give written reply related to this question. So does it mean we have to extend the scrutiny period? If not, I'll report to the House Committee tomorrow. And then we'll go to second and third reading on the 26th of June. It's a case of negative vetting, so there is no second or third reading. Then everything will be completed on the 26th of June then. Do we have to sign up if we want to say anything further? Do we have to sign up? Yes, you have to sign up. There will be a form. There will be a sign-up form for you. I think the form is about request to speak. So other members can also request to speak. If no one requires to speak, then no one will speak. But if anyone requires or asks to speak, all other members can also ask to speak. All right, we'll bring the matter to the council meeting on the 26th of June. I don't quite get it. So if anyone wants to speak at council meeting, he should sign up. And if one signs up to speak, the other members do not have to make their individual application to speak. I think Mr. Leung wants to speak his mind now. For amendment ordinance scrutinized under subcommittee, the chairman of the subcommittee will speak, will report the matter. So in that case, the other members do not have to sign up to speak. So I won't sign up then. We will not extend the scrutiny period then and report the matter at council meeting on the 26th of June. I will report the matter at the House Committee tomorrow. That is the 14th of June. We don't have any AOB. Meeting adjourned. Thank you.
口頭報告啊，簡單嘅幾個字得啦。